we're good for you to start.
Okay, Chair, over to you, and we're good to get started.
Perfect. Good afternoon, everyone. Thank you for joining us for today's DNC Rules and Bylaws Committee. I am Mignon Moore, and I serve as the co-chair of this committee alongside my great colleague, Jim Roosevelt. So before we begin, can you please join me in reciting the Pledge of Allegiance? I pledge of allegiance
to the flag
of the United States of America and to the republic for which it stands,
one
nation, under God, indivisible, with liberty and justice for all. Jim, would you like to do the roll?
For the record, that this meeting is open to the public and will be live streamed today. Please be sure to state your name before speaking for those listening remotely and for our court reporter. We're glad to be joined once again by Helen McFadden, our parliamentarian. Helen, will you call the roll?
Thank you, Mr. Chairman. Mr. Applebaum.
Present.
Ms. Blanco.
Presente.
Ms. Brazil.
Here.
Mr. Brennan.
Present.
Mr. Burgos.
Present.
Ms. Cardona.
Presente.
Yes, sir. Ms. Cardona.
Presente.
Mr. Curry has given his proxy to Mr. Applebaum. Ms. Daughtry.
Here.
Ms. Dowdell.
Here.
Mr. Elete.
Here.
Ms. Fowler.
Here.
Mr. Aridia.
Here.
Ms. Kmark. Mr. Leon.
Here.
Ms. Lewis. Ms. Lewis was visible earlier.
Helen, she waved her hand there, so
Okay.
I see her hand raised.
Okay, thank you. Mr. Locke. Ms. McGarrick has given her proxy to Mr. McGlinchey. Mr. Martin.
Here.
Ms. Martinez.
No. I don't know what is this?
Zoom.
Is Ms. Martinez present?
Actually, it's at the top.
Okay. Mr. McDonald.
Here.
I heard Mr. McDonald. Mr. McGlinchey.
Here.
Thank you. Mr. Mitchell.
Here.
Thank you. Ms. Mount.
Here.
Thank you. Mr. Ray.
Here.
Mr. Saunders.
Here.
Mr. Spate.
Here.
Ms. Schwecker.
Here.
Mr. Thompson has given his proxy to Mr. Elete. Ms. Weingarten.
Here.
Ms. Williams. I saw Ms. Williams earlier.
Can unmute.
I'm here.
Thank you.
I'm here.
Thank you. You have a quorum, Mr. Chairman.
Thank you, Helen. Per our charter and bylaws, a quorum is 40% or 13 members in person or by proxy, and we certainly have that present. Before we begin, I want to recognize the team who works behind the scenes to make sure our meetings run smoothly. We are joined by the Party Affairs staff, Director Veronica Martinez-Roman, Special Assistant Jenna Whitaker, and former Director and longtime advisor of the department and the party, Rick Boylan. I'd also like to thank Cody Voiles from the DNC Tech team and Weymouth Watson for assisting our production. Our sincere thanks to one and all. Mignon?
Thank you, Jim. And I'd also like to thank the staff, but I also want to thank the members who are showing up for these meetings and giving of their time. So today's focus for us is to continue drafting the rules and the call. But before we begin, we will update you on the pre-window process to date that Jim and I have been going through with the staff. Are there any questions regarding the agenda? Hearing or seeing none. Jim, you want to?
Thanks, Mignon. Since our last meeting, we've moved forward on two aspects of the process for reviewing pre-window applications that we discussed with you earlier this month. On July 13, the Party Affairs Office sent a request for additional information to the 17 applicant state parties, and we received responses from all applicants earlier this week. Per the request of several members, we are compiling this information into a sheet for members to review and have on hand as we get closer to a vote. Additionally, Mignon and I have met with several state parties to discuss the issues covered in the questionnaire in more depth, including matters related to the feasibility of states moving their contests and generally making our whole process work if they are selected. Those calls have been deeply informative, and these are discussions that will continue in the coming weeks as we move closer to a vote in the pre-window on the pre-window rule. As we've discussed previously, these are sensitive conversations, and we do not want to jeopardize any state's ability to get the job done. So we are not going to go into detail on those conversations at the moment. But we can say we are pleased with the progress that states are making in this regard, and these conversations have been extremely helpful to Mignon and me as we prepare our recommendations for you ahead of the August meeting. Now, on that note, we are meeting today to discuss a variety of topics, but I want to stop here and open it up for discussion of the pre-window process. Is there any discussion that anybody would like to raise?
Chair, I see two hands raised, Chair Lewis and Randy Weingarten.
So,
Ms.
Mr.
Lewis,
Chairman?
go ahead.
Mr. Chairman, thank you. I just wanted to say that I am extremely happy today. I feel very gratified today. And those of you that have been following the news, you know that Maryland is on the verge of electing the most diverse ticket in the history of the United States of America. We will have an African-American governor. We will have a lieutenant governor who's a member of the AAPI community. We will have the first African-American male attorney general, first African-American attorney general, and the first female comptroller of the state of Maryland. If you look at Maryland, you see America. And I am just bursting with pride at what we've been able to do. The race has been called by all except the Associated Press, and we expect that that will happen shortly. But NBC, CNN, and CBS have all called it. But this is just a further indication that Maryland doesn't just talk the talk, we walk the walk. And I just had to gloat a little bit and stick my chest out with pride at what the state of Maryland has been able to do. And I'm very excited. So thank you for indulging me.
So thank you and congratulations to you and your colleagues and to all of the candidates in the primary who put on a great race, giving a very good set of choices for the people of Maryland. Who is next, Veronica?
We have Randy Weingarten.
So can we, here, Yvette, for running an amazing primary process and for everything that happened over the last few days. You have a lot to be proud of. So I had a question about, are there, in terms of the early process, are there some immovable or immutable or still to be determined questions that different states have to do, so that when when we have those final conversations, we know what they are walking into those conversations. So, and I think that in kind of listing them, and yes, so one of them would be that New Hampshire says under its law, blah 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 blah. Sorry, I don't mean to, be derogative at all. One of them may be Michigan has yet to change its law, but what are where are they? So I just think that if we had those questions and kind of the status before the 5th or 6th, then the entire committee and the public would know where things are on those issues, rather than, and I don't know about your memories, Mignon and Jim, but I don't remember anything from moment to moment. So it's like out of my head from our conversation about it.
So Mignon, of course, remembers each detail of every state's process. But in fact, these are the questions when those things have not been clear that we've been going back to the states about. We've had, in addition to running through a conversation with each state to start with, then sending out our questionnaire, getting the answers, we've gone back and had individual conversations with about a dozen more states where their answers were not absolutely pinned down. Mm-hmm. So that's what's going to go into this sheet staff is going to prepare.
Right.
And we continue getting states sending in little pieces of information. And although we had a deadline for people to send information, this is not a public RFP process. So as people have more information and we get it, we include it in what will go to the whole committee before the August meeting.
I see Donna and Mo.
Yes, Donna is first and then Mo.
Thank you so much. And first of all, I want to congratulate all of the states, and especially many of you who have had really competitive primaries over the last couple of months, like the state of Maryland, where our former chair, Tom Perez, competed. But I just want to say that in terms of where we are today versus just a few months ago, there's more enthusiasm that we're seeing among Democratic voters. Voter registration is increasing across the country. And of course, the voter protection plans that we have in place are being implemented. So I just want to congratulate all of the states, all of the state parties, and all of our candidates. We're going to have one hell of a midterm election cycle. And I am still optimistic that with the leadership being provided by our president and vice president, and all of our other many Democratic officials, we're going to surprise a lot of people. So my question is, consistent with our mission, as we said earlier this year, we're going to make sure that the states that we consider meet certain of our principles: diversity, competitiveness, ability of the party to win in a general election, and the feasibility, of course, to ensure that the scheduling is done in such a way that we can ensure a fair and transparent and inclusive nominating process, and all of the logistical requirements are being met. So I have two questions. One is, are we still looking at 17 states? I got my own little map, and it's a beautiful map. It shows all these wonderful states. I've been to all, so thank God Montana's now on the list. But I say that because I've not visited Montana. If I visit Montana, I would have visited all 50 states, thus becoming Miss USA without the bikini. But are we still looking at 17 states as of today? We've not narrowed it any further. We're still looking at everything from New Hampshire all the way up to the great state of Washington, all the way down to the beautiful state of Georgia, and the big neighboring state of mine is Texas. So we're still considering all of these states, correct?
Jim, are you answering or should I just answer?
I'm happy to answer. The answer is yes. And as we've circled back to some of the states, we've tried to be fairly candid with them about whether they all put in strong presentations and made strong appearance with us, but about whether on the merits they are among the strongest likelihood. And we do that so that they can gauge how much effort they want to put into the continuing in this, because they have plenty of other things to do. But we've not told any of them that they're out of the running because they're not.
Mm-hmm.
Right.
And Donna, I will add to that. In doing these states this week with Jim and the staff, it's been very interesting to listen to the states off camera. And so you even get more information from them. And I think the fact that we have tried to respect each state who has put a lot into this, I think it will go a long way in making sure the party is cohesive at the end of the journey.
Excellent, excellent. Well, I want to just go ahead. I'm sorry.
I'm just going to comment that although we have discouraged the states from approaching individual members, we know that some have, and some have been approaching both Mignon and me, and we've seen names come up on our phones that we didn't recognize who turn out to be United States senators. So
yeah, I've had a few of them, and I was worried they were trying to get my $35 contribution, but they were calling, along with many other state officials. I want to speak one final second to this notion that we discussed previously about tradition and why it's important that as we look at these, the last 17 states, that we not only look at the historical nature of the traditions that we have followed for the last several decades, but we look at a new tradition, a way of looking at the country going forward, not just looking backwards. Tradition has many meanings. It has many, but it also has many challenges. And we know that from generation to generation, we try to maintain some norms and decor. But I think in looking at where we go ahead, we look at how this party can tell a different story, an American story, a country that has embraced not just its diversity, but as a strength, but a country that is looking to giving a new generation of American voters an opportunity to participate in this process and to write their own story. So I was on the last commission, the Price-Herman Commission, and I was delighted in what we came up with adding a southern state as well as a western state. And I just hope that when we look at the final decision that we will make as leaders of this committee and as members of this political party, that we look at the future and write a new chapter, a new story, and one that we can also be proud of. So with that, I don't have any other comments for now.
Chair, we have Mo Alithi.
Mo?
Thank you. I know I echo everything that's been said about the quality of all the applications from all the states. Is it appropriate at this point, given that this is our last meeting before the August meeting, and you guys will be, I assume, leading that conversation in August with some form of proposal. Is this an appropriate time for us to start offering our thoughts on where we stand as we begin to think this through?
I think, Mo, it's the appropriate time to offer your thoughts on process. I think we'll circle back for your thoughts on what the actual outcome ought to be.
Mm-hmm.
Okay.
Yep.
Thanks.
Mm-hmm.
Anyone else on the process? Okay, thank you for those great thoughts. And I will turn it back to you, Mignon.
Great. So we get to pick up where we left off at our last meeting. We made significant progress on drafting the 2024 delegate selection rules at our meeting earlier this month in May during our virtual meeting. So as we look at our proposed updates to the rules, I'm mindful of other potentially large changes we have been discussing this summer, and I want to stress the necessity to provide states parties with consistency. We must absolutely ensure our rules are accurate and reflective of lessons we've learned since 2020. But in terms of large-scale changes, we should be mindful not to create other major changes as we head into the election season. I think that's called, if it's not broke, let's not break it. Since our last meeting and the May virtual meeting, party affairs have updated the rules and called to reflect the language we voted on and provided suggestions as requested. For both the rules and the call, we will follow the same process, starting with the rules. We will review the changes as voted on in July or recommended by party affairs. We will ask if any members wish to discuss the recommendations, but before we begin digging in, we will see if there's any specific sections that members wish to discuss. Helen will help us track any sections of the rules that a member has suggested for additional discussion. Once we have a complete list of rules for discussion, we will begin moving through them one by one. Our intent here is to present the changes we've made for your awareness, bringing forth the recommendations for your review, and create space for you to raise any new issues. We've now had 2 robust discussions on rules as a whole, but limiting our discussion today to our recommendations or our new issues, we hope to streamline our drafting conversation and complete the editing process, except for a couple of matters that are deferred until the August meeting, where once those matters are resolved, the documents can be adopted by the committee and recommended for the approval by the full DNC. Are there any questions to that long soliloquy?
Chair, I see David McDonald's hand.
Thank you. Mignon, I just wanted to be clear because the notice for the meeting today had talked about finalizing rule changes. And at the last meeting, there was some discussion about having a discussion in August about Rule 14B. In the meantime, Elaine Kmark and I have suggested fairly generic language that would obviate the discussion in August and probably put any detailed discussion into December. And I just wanted to verify that we can have discussion about that proposed language on today's agenda, not necessarily now, but someplace in the agenda. Is that correct?
Yes.
Thank you.
Mm-hmm. Any more questions?
I'm not seeing any.
Okay, go ahead. I'm sorry, Veronica.
Oh, no more questions. No.
Excellent. So let's begin. In terms of updates based on our committee's votes in July, Party Affairs has replaced instances of he or she with gender-neutral pronouns. In Rule 13G, they changed the terms units to districts to mirror the usage of districts elsewhere in the rules. Additionally, they removed 15D and will renumber the document after we finalize the draft. Per our request, Party Affairs offered the following recommendations with the support of the co-chairs. I am going to review the the whole list before we discuss any individual rules which you wish to flag in today's discussion. Please write down any recommendations you'd like us to revisit, and after I finish the overview of the proposed changes, I will ask for any additional points from members that members wish to discuss. Once we have a list of the rules we want to discuss further, we will go through them one by one. So here we go. Rule 2H. At our last meeting, we reviewed 2H, which requests that state parties include a description of actions that they have taken or will take to seek to enact. Let me start over. State parties include a description of actions that have been taken or will take to seek enactment of legislation and policies to enhance voter and election security. This is not a new section, but Frank requested that we add a section to Rule 2 with similar type of language related to election subversion. We felt this proposed language was related to election security and made sense to be included in Rule 2H, rather than create a whole new section. Thus, we are proposing to add the following language to 2H, which you could follow along on the screen. In 2H, after the words "to seek enactment of legislation, rules, and policies at the state and local level, voter and election security," add the phrase "and combat election subversion." To Rule 2H7, after the phrase "use accessible and secure voting machines that make it possible for individuals with disabilities to vote securely and privately," add "with votes verifiable by voters." Add Rules 2H 8 through 10, which reads, 8, provide educational materials to enhance public knowledge and confidence in election administration and counter disinformation. 9, actively engaging with state and local elected officials to implement fair and honest election policies and practices. 10, support adequate funding of state and local election administration. If you would like to discuss any part of this recommendation, please take note now and let us know after we're finished reviewing our list of recommendations. Rule 2 is at Rule 2.1(I)(a), and Rule 2.1(I)(1)(a), we have inserted the term drop boxes following the words same-day voter registration in the current rules. So it reads, expand access to voting, including by early voting, no excuse absentee, same-day voter registration, drop boxes, and voting by mail. Again, if you would like to discuss any part of this recommendation, please take note and let us, after we finish reviewing our list of recommendations. 2K5. We do not have any changes to 2K5 itself, but I did want to draw your attention to it as it affects two rules, 11C and 14B. We are changing later in the document. We are simply updating those two rules to be in line with Rules 2K5, which requires that the allocation of all national delegates be locked in at the final expression of preference at the first determining step, as determined by the state's plans, which is part of the reforms recommended by the Unity Reform Commission. The 2020 rules added this rule to require caucus states to lock in the allocation of all national delegates at the final expression of preference at the first determining step. However, Rules 11C and 14B continue to include the old language, allowing caucuses to designate the step where they will determine how the at-large and pleo will be allocated. This clearly conflicts with Rule 2K5 and needs to be updated. So while we don't have a change for 2K5, I wanted to highlight it for you when we have time, when we discuss the other two rules. Rule 6D reads, for purposes of providing adequate notice of the delegate selection process under Rule 3, the time, dates, places, and rules for the conduct of all caucuses, conventions, meetings, and other events involved in the delegate selection process shall be effectively publicized, multilingual, where necessary to encourage the participation of minority groups. Lastly, Molly McGarren suggested that we add language relative to accessibility. We are recommending that we change shall be effectively publicized, multilingual where necessary to encourage the participation of minority groups to shall be effectively publicized to encourage the participation of minority groups. Parties will make a good faith effort to publicize this information in accessible manner and multilingual where necessary. If you would like to discuss this part of the recommendation, please take note. And after we finish, we'll go through the list of recommendations. 11C, as previously noted, Rule 11C must be updated to align with Rule 2K5, which requires that the allocation of all national delegates be locked in at the final expression of preference at the first determining step. We recommended removing the language in 11C that conflicts with the change made in the 2020 rules. In the sentence, at-large delegates and alternates, including pledged party leaders and elected officials and elected official delegates, which shall include those to be allocated to the uncommitted status. In primary states shall be allocated according to the statewide primary vote, or in states holding no statewide primary, according to the division of preferences among convention and caucus participants. Delete the phrase "or" in states holding no statewide primary, according to the division of preferences among convention and caucus participants. In the sentence, in non-primary states, which do not hold state conventions authorized to elect delegates, at-large delegates shall be apportioned according to the division of preferences among district-level delegates at the time of district-level selection. Delete the phrase, which do not hold state conventions authorized to elect delegates, and replace that phrase with division of preferences among district-level delegates at the time of district-level selection, with final expression at the first determining step, which reflects Rule 2K5 language. Once again, if you'd like to discuss any part of this recommendation, please take note and let us know after we finish our list of recommendations. 12B, and if I need to slow down, please let me know. In line with our conversation at the last meeting, we recommend changing the phrase, including the filing of presidential candidates, to accept the filing of presidential candidates as allowed by Rule 15D, and have the rule read, all steps in the delegate selection process, except the filing of presidential candidates as allowed by Rule 15D, must take place within the calendar year of the Democratic National Convention, except as otherwise provided in these rules or specifically allowed by the DNC Rules and Bylaws Committee. This change will significantly reduce the number of waivers needed while still ensuring committee oversight of processes as needed. Again, open and fair process. If you want to discuss this after we finish, please make sure you take note. 14B. In 14B, we recommend removing the phrase states which use a caucus/convention system shall specify in their delegate selection plans that the caucus level at which such percentages shall be determined. So this rule aligns with 2K5, which requires that the allocation of all national delegates be locked in at the final expression of preference at the first determining step. Guess what I'm going to say? If you'd like to discuss any part of that recommendation, please note and let us discuss it after we finish our list of recommendations. 15E. Rule 15E states no deadline for the filing of petitions for participation in the presidential nomination process by a presidential candidate shall be less than 30 days in advance of the primary or caucus, no more than 75 days in advance of the primary or caucus. We recommend changing the upper limit from 75 to 90 days to assist with the waiver issue. I will repeat the rule numbers that the Party Affairs offered recommendations for. Please use the Zoom function to virtually raise your hand if you have any questions regarding these recommendations, or if there is a different rule you'd like to discuss. Would anybody like to discuss the following rules? 2K5, 2H, 2I, 1A, 6D, 11C, 12B, 14B, 15E.
Chair, I see David McDonald's hand raised.
Thank you. With respect to Rule 11C, we make reference in the last sentence to a candidate, to a person who is no longer a candidate. Is it our intent to define what that means in the regulations in terms of people who have suspended their campaigns but may have suspended them for health reasons and decide to resume before the convention? If not, should we? I think we might want to be clear in this rule as to what it means to no longer be a candidate.
Okay. Jim?
My reaction is that yes, that should be in the regulations. As difficult as it is to go through these rules, we want to at least leave some of the detail to the regulations so that these are more readable as we go through this, and particularly what we've just done. I think a little bit about the old joke about the person who'd been on the same cell block for 10 years and it would say now joke 10C. But so I do think that is appropriate for the regulations. We'll make note of that, Veronica, and David would feel free to bring it up again when we talk.
Yeah, I was just flagging it. That's fine.
Yep. Frank?
And sorry, I also want to discuss 14B when we get there, but you may have other business to take care of before we get there. So you can mute me back off again now.
Yeah, thank you. Frankly, I was just going to ask if the chair could explain a little more about what goes in the regulations and what goes into the rules. Is there a general approach to that? We've got some new people on the committee and some people who aren't new people on the committee who aren't quite sure how that works. Can you maybe discuss that a little?
So in general, I would say that the rules set the overall parameters, that there are specific things that will apply in a few situations, and maybe even more than a few, that go into the regulations in order to carry out the rules. I think we actually might turn to Rick Boylan for a little comment on that, since he has often managed that distinction in the past.
Heard your thoughts on that on the other side.
I'm happy to do that. So the regulations have generally been the document where the Rules and Bylaws Committee's decisions or interpretations of the rules have been codified. So, for instance, in the David's question about presidential candidates, that's an interpretation that the Rules and Bylaws Committee can make that clarifies that particular rule. That's a lot of times what the regulations are used for.
Thanks, Rick, and good question, Frank.
Chair, I'm not seeing any other hands, but I'll give it just a moment.
Mignon, did you intend to go back to David for another rule?
Yes, he had 14B that he wanted to discuss. And I see. David, did you?
Yes, thank you. At the last meeting, we discussed to some extent the emerging problem. It is an actual problem in my state, but I think it will be emerging elsewhere, of encouraging early voting, where voters have a ballot that has a list of candidates, and then by the time their vote is counted, some of those candidates are no longer eligible and their vote may be wasted. We've discussed one tool for dealing with that, ranked choice voting. We discussed the fact that that's not the only tool that might deal with such a situation. In particular, Minnesota, as Ken indicated, has a clawback mechanism that works. There may well be other tools. And we deferred to August potential discussion, I think, either of ranked choice voting or of general mechanisms. What Elaine and I talked about, we should just submit language to you that at some point we'll put up on the screen. But our intent was to come up with some generic language that did a couple of things, that said, these rules do not intend to prohibit anybody, any state, from developing a mechanism to mitigate wasted votes if you're going to use early voting. That the question under such mechanisms of what is a final vote is a question of interpretation. And therefore, the regulations may end up explaining what restrictions there will be on counting or how you determine what the final vote is in such situations. But this rule does not create a safe harbor or endorse any particular mechanism for mitigating wasted votes. So the basic concept here is to say, we have a lot to do in August. We've said it, we have effectively said, there may be ways that you are having second choices in your states. If you do, our present posture is we don't prohibit it, but you better look at our regulations to see if we have some restrictions on how you would implement it or how it would be used. And at least from my point of view, and I think from Elaine's, if we were to adopt this kind of generic forward guidance, we would no longer need to discuss the subject at the August meeting. And therefore, I request that we add in this sentence also, this section, excuse me, also in the last sentence makes it clear that there are no challenges based on preliminary votes. That if you have any form of second choice mechanism in place, you have to use what we interpret as the final vote to allocate delegates, not some other interpretation. And with that, that's all I had to say.
Okay.
I see that Frank has his hand raised. Is that to comment on this discussion or a later one?
This discussion.
So please.
I guess I'm a little confused. I appreciate David raising this issue and circulating this proposal, but my understanding is we're going to discuss ranked choice voting in August. Now the idea is if we adopt this, we don't have to discuss ranked choice voting in August. And I think the reason is that we're already approving ranked choice voting. Is when we talk about a second choice per voter, that seems to be ranked choice voting. And it may well be that this committee is going to do that, but I don't understand why we need to address it now as opposed to addressing it and addressing all the pluses and minuses of ranked choice on the merits, which I will refrain from doing now. But I would suggest that we just put this off till August and discuss it when we discuss ranked choice voting.
Elaine, did you want to comment on this?
Let's see. Yep. Am I unmuted? Okay. Yeah, I'm agnostic on when we were going to discuss this. In fact, I've sort of lost track of that discussion. I have one worry about this, which I think this language addresses, and which I talked about at, say, the meeting before last or 2 meetings ago. States have gone ahead and used ranked choice voting. A couple of states used it 2 years ago. I think we have a precedent for allowing it. I don't have anything against it. My problem with the not saying anything is that in a contested nomination fight, if we're not clear that it is the final choice that determines delegates, you can absolutely see a situation where candidates who did sort of well on the first go around, but lost out on the second one, challenge. And obviously the entire point of having these delegate selection rules is to diminish the number of challenges and make it clear to everybody how we're going to do our business. So I think that the important issue here is the issue that says, and the computer's in my way, let's see, delegates shall be allocated on the basis of the final vote, and credentials challenges must be based on the final vote. And I think final vote is something that we can, thank you for making this bigger for some of us who couldn't see it. And final vote is something we can deal with in the regulations or not at all. It's just that the way this was introduced a couple of meetings ago, it left open the question of where you're allocating the delegates, and in fact made it look like, wait a minute, we had one rule that said 15%, and then we have another rule that maybe people with 15% would get left out of the delegate count. Apparently that did not happen. There was no confusion. That did not happen in the 4 states, I believe, that used this 2 years ago. But, our job is to, plan for the worst scenario. And the worst scenario is a tightly contested nomination where everybody is fighting over every single delegate. So that's why I think this should be addressed at some point in the rules. I think it's useful to have this discussion today, let people think about it. I don't know. I'm sorry I had to come in late today. So I assume that we're just discussing these things today and we're not voting on anything. So I assume we'll have another crack at this in August. But I think it's something we have to make clear.
Thank you, David, Frank, and Elaine for that. And I think the staff has taken note of all the comments, and we will look to discuss it again. Jim, I don't know if you want to add anything to that.
No, I think that's it.
And I thought I saw Artie's hand up, but maybe not.
Chair, I don't see her hand raised, but it looks like Artie was nodding. Artie, are you all set? She's good. Oh, I see David's hand up again.
Artie should go ahead before me. So.
She's fine. She doesn't. She's indicated she didn't want to speak.
I'll go ahead. That's okay. I'll go ahead and just ask. I did want to ask more of the language. I guess my question was how this is only giving the opportunity for states to allow it, but we would still have to divide what Elaine just said. We would still have to define the regulations in the regulations component. But if this language is too open, if that is the concern, I think, I'm interested to look into this as an option so that, whatever way we're limiting sort of challenges and options in that way, I think we should sort of look at that to allow for people for a second choice if, depending on what their process is.
Mm-hmm. I think that's fair. And I think between Elaine and David and Frank, we've raised sufficient concerns that we probably need to take another run at this for the committee. Frank?
Go ahead. I think David was next.
David.
I guess I'm a little confused because this is intentionally not having a discussion about ranked choice voting. It is intentionally not blessing any mechanism. And I want to be sure we're not somehow converting it into a discussion of, do we think ranked choice voting is a good idea, as opposed to, do we think it's a good idea for states to come up with ways to keep people from wasting their votes? And at least my intent in submitting this language was to say, look, let's be clear to the states. You can come up with a way to avoid wasting votes, but you have to make sure that you comply with our guidelines as to what's a final vote. You don't have just a free rein. Where we are right now is we're very clear that our rules do not prohibit anybody from using any voting system they want. And we also have no place in our rules where we say, but check our regulations to see if we've outlawed your voting system that you've adopted. This is the Wild West. And so I'm just trying to put in language that says you can deal with the problem, but we may regulate it, and you need to check our regulations, but also to take that discussion that's going to be granular out of the meeting at which we're going to be discussing which states go up front and probably some other big issues. So I was a little confused at the suggestion, partially from Frank's comments that bled into, I thought we were going to discuss ranked choice voting, and now we're discussing ranked choice voting in August, and we're not doing anything about this. I would urge us to do this minimum generic step. And then if we're going to have a discussion about ranked choice voting or the details of any of these implementations, to do it in the regulations as part of what it means to be the final vote. Thank you.
Jim, do you have anything you want to add to this discussion, or?
So I am actually comfortable with that approach, so that this rule, proposed rule, specifically says we are not prohibiting one method or another, but we're saying the method has to be defined and we have to approve that method. That does strike me as a classic example of something where there's discretion for the Rules and Bylaws Committee that will ultimately be codified in the regulations. So I am comfortable with this amendment as it stands right now. And I would point out that should we, when we get to discussing the regulations, find that there's something in here that is not consistent, we can go back and amend this.
Mhm.
Chair, I have Donna Brazil and Frank Leone in the queue in that order.
Postman. I hate to go in between lawyers because I always feel like I'm going to get it wrong. But here's my point. If I'm a candidate for president of the United States and for whatever reason I decide to withdraw, but my name is still on the ballot, the question is, what process will be undertaken to do what? What are we trying to do?
So
I could withdraw. I could withdraw for many reasons. I could withdraw because hell, I've run out of money. I've run out of steam. Y'all know how many presidential campaigns I've worked on where my candidate has had to withdraw after Super Tuesday or after Iowa, New Hampshire, or South Carolina, Nevada. So what are we trying to get to? I know early voting starts in many states, sometimes 2 weeks, sometimes 6 weeks ahead. People go start voting in the general election for 2022 in September. So what are we trying to solve? That's what I'm trying to figure out.
If I understood Frank's earlier premise, early voting starts and then a candidate abruptly gets out, for example. I thought he was saying, is there a provision that these people could come back and amend their votes? I thought, what were you asking? Okay, maybe I got that wrong then. Okay.
That's why I said I'm going between lawyers. But my particular point is early voting starts in many states, 2 to 4, and in some cases 6 weeks out. And are we saying in the nominating process, because we're not talking about the general, we're talking about the nominating in the presidential nominating process. If a candidate withdraws for whatever reason or suspend, whatever reason, is that what we're talking about? Withdraw, suspend, or what are we talking? I'm trying to get to what we're trying to solve.
So let's talk about suspends, because almost every candidate suspends, right, withdraw. Okay. And I think what we're talking about is, let's say that we have early voting for a primary that is taking place on the first day in the regular window. Okay. So that early voting takes place all through February. But in February, we have the 4 or 5 early states. And by the time you get to the third or fourth one of those, somebody is persuaded that they should suspend. However, some of those people voting in the regular window will have names in front of them while those candidates are still active, but by the time the votes are counted, they're not active. What we're talking about is a mechanism to make sure that they have an opportunity to feel that they really participated, understand that they really participated in this process. I don't think we have the answer to that mechanism yet. What I think this rule is trying to say is states can propose a rule. Last time we just didn't say anything, and states, 4 states, I guess, went and did ranked choice voting. That seemed to work, but on the other hand, there wasn't much consideration of the pros and cons on that. And I've heard various reports about whether voters understood what they were doing and so on and so forth. So what this is trying to say is there may be a need for people to have an opportunity to make their vote meaningful in some other way because of candidates having suspended their campaigns. That we need to learn more about that. That's exactly what we do with the regulations. We interpret more. So I think this is trying to say, if you read the sentences at the end, they have whatever we decide in the regulations, states will have to comply with. We aren't saying what those regulations will be yet.
Yeah, and I thought it would be more appropriate for the regulation. And by the way, Jim, you mentioned one last thing. The 4 states, they were caucus states, right, in 2020 that held ranked choice voting, right?
I believe that Maine may have done that in a regular primary.
Well, Maine is one of two states that currently have ranked choice voting.
Yeah.
All right, thank you. You've answered my question, and thank you for your patience and
well, no, that clarifies.
Lawyer more educated.
As usual, I think you clarified it for everybody, and so it's basically what we're saying is that adopting this rule would not provide a final answer. It would provide a mechanism for getting to a final answer.
Right.
David, would that be a fair characterization? You are muted, David.
Yes, I think that's a fair characterization. This is in one sense, it's not changing the status quo because right now we don't prohibit anything, but it is signaling that we may prohibit something. We may put restrictions on it. We may further explain it. And we realize that there is a potential issue that didn't exist 10 years ago before we started pushing early voting. So it's sort of, here's the status quo. Feel free to try to address it, but be aware that we may have concerns about how you address it. So you might want to pay attention to what we do in December, or if you're thinking about addressing it, you might want to talk to us ahead of time, particularly if you're a legislator, to find out what our concerns might be. That's the basic framework. And then Elaine's final sentence that however you address it, whatever we at the DNC determine is the final vote will be the way the delegates are allocated, not whatever you put in your statute will be the final vote. That's the end of the discussion there.
So Mignon, I see several other hands raised.
Yes, Frank, Elaine, and Scott.
Yes, I guess I'm still a little confused. The language that nothing in this rule is intended to prohibit a state from providing a second choice to a voter who cast a ballot for a candidate who is ineligible to be awarded delegates. To me, that says you can do ranked choice voting, and it may be that we want to do that. I don't think we need to do that. I think the whole purpose of ranked choice voting was to replicate for mail-in votes the in-person caucus experience of realigning, and nobody is doing that anymore. So it's not clear to me why we want to re-add caucus math to this whole process, as well as set up a process that is less transparent and that will result in the reason why we need the sentence at the end is because the first results may be different from the last ones, and people will claim they won even if they didn't. And so I don't know why we need to go into all of that, but that's on the merits. I don't understand why we need to have a provision that now then, to me, seems to approve ranked choice voting, although we're saying it doesn't. It doesn't clarify anything for me. It confuses it even more. Now, if we took out the first sentence and just say, if the DNC allowed a process providing for second choice to voters, then blah, blah, then that maybe that gets to what David and Elaine want to do without specifically, it appears to me, blessing a process that, again, we may want to do it, but we haven't had that discussion yet. That's all I'm going to say.
Okay. So I think in queue is Elaine, Randy, then Scott.
Because I think that David clarified this. But I think we do have to, I'm not sure that we have to have Frank, I'm not sure we have to have a yes or no discussion on ranked choice voting because we allowed it last time. I mean, there's precedent for allowing it. The state, as I understand it, some, if not all of the states that used it last time they really weren't caucus states. They were firehouse primary states. They were people just coming and filling out ballots. They really weren't caucus in the old fashioned or the Iowa form where people actually sit in the room and move from one group to one group. So it seems to me we already did that. We already allowed for this. It seems, I think the state of Maine is the first state that has made this universal for They're state-run elections, so we're going to have to confront this anyway. And so I was just trying to, I think David and I were both trying to clarify that if you're doing that, you have to make sure that we review it and that there is no challenge provided on the basis of other than the final vote. I think that's all, but I don't know that we really have to have a yes or a no on ranked choice voting, since we already did that. So that's all.
Oh, thank you, Elaine. Randy, then Scott.
Thank you. I just want to piggyback on what Elaine said about half an hour ago, and I think said again now in an earlier rule, which is, I assume that the only reason ranked choice voting is at all opposite here is for for all those who voted for someone who got less than 15%.
Mm-hmm.
And so that their second choice would then get, so then they could have a second choice for those under 15%. Other than that, ranked choice voting doesn't really work in this primary process because it is a race for delegates.
Mm-hmm.
And so what I thought Elaine did in 14B or something like that earlier was make that clear that would be that people want to do it, they do it, but only in that scenario, and then regulations should be written about it. And I think that that's really kind of the decision point, which is to make it clear that ranked choice voting is only there for those who have voted for a candidate who got less than 15%.
Mm-hmm. Thank you, Randy. I think that is what Elaine has stated twice.
Yeah. Exactly.
Thanks. And I'll be very brief. I just think the amendment is a fairly simple way of moving us toward a discussion that we at some point need to have. It just sort of opens the door toward talking about the regulations. So I guess I view it as relatively innocuous.
Oh,
thanks.
Thank you. So do we see any more questions in the queue?
Chair, I'm not seeing any more questions, just looking for hands. Nope, I think we are all set.
I believe that we are moving on to Jim now.
All right, thank you, Mignon. And let me just confirm with Helen that we've gone through the any list that you have of things that we still needed to discuss.
Mr. Chairman, Mr. McDonald noted his issues with 14B. That is what the group has been discussing. He also noted an issue with 11C. Further now, as to 14B, Mr. McDonald actually made a motion, and based on the discussion, you have a second. So I think the question is whether the committee wishes to vote today with regard to that language or postpone it to the next meeting.
So are you saying, Helen, that we actually have in effect a motion to postpone in front of us?
Not yet. Mr. Leon spoke briefly to that point, but he never made a motion.
Mm-hmm.
So the only thing you actually have pending is Mr. McDonald's motion.
So, Mignon, shall we we could do one of two things here. We could either move to a vote on Mr. McDonald's motion, or we could actually say the chair will entertain a motion to postpone Mr. McDonald's motion to the August meeting.
I think we should entertain a postpone if that's in accord. I mean, Jim, I can.
Someone needs to make that motion.
Yes.
If they want to postpone it. Mr. Apple was raising his hand.
I'll make that motion.
Is there a second?
And Ms. Blanco was raising her hand, but I think she was.
I will go ahead and second this motion, but I'd like to ask that when we meet in August, that this language is inserted in the draft that will be before us. So if I can make that request, that would be helpful, I think, for us in the discussion.
So if we postpone it, it won't be inserted as part of the actual draft, but we'll make sure that it is before everybody for consideration. To actually insert it, we need to basically take a positive vote here, but it'll come up for discussion.
Chair, I see David McDonald's hand as well.
David, you're on mute.
Yeah. I would just urge people to go ahead and vote on this because we have been discussing this issue. And the amendment is really a very narrow thing, but we keep coming back to wanting to have a discussion about ranked choice voting. And we'll just be having the same discussion in August that we had today, I think, if we don't just go ahead and vote it. I may be misreading the room. I've certainly done that in the past. I don't really think that there's that much interest in talking about this again and again and again. And I would urge us to vote down the postponement, put this language into the draft and take it up when the whole document is presented in August. Thanks.
Veronica, does anyone else have their hand up?
I see no more hands.
So Mignon, you may want to go ahead and just move to a vote on the motion to postpone.
Well, Jim, you just moved to a vote on the motion to postpone. Let us roll.
So, all right. All those in favor of postponing, please, since we can't do just a voice vote, please raise your hand either physically or the raise hand function.
If you're raising your hand physically, if you don't mind just keeping it up for a minute here so I can make sure we don't miss anyone, and do not click the raise hand on your computer. So pick one or the other.
And as usual, if you have a proxy, we'll raise both hands.
Four, 5, 6. Just one moment.
Mr. Chairman? Mr.
Yes.
Chairman,
Yes, Helen.
Veronica and I together have counted 14 votes in the affirmative. We need to get the negative vote.
So we're asking everyone to put their hands down, both physically and on the screen. And those who are opposed to the motion to postpone, in other words, those who do not want to postpone, raise their hand now.
Mr. Chairman, Veronica and I each count 9 in the negative.
So the motion to postpone carries.
Yes, sir.
All right. So Mignon, I think that is the signal for me to pick up the next topic. Is that right?
That is correct. Thank you.
Okay. So we'll move on to the call for the convention. We will review the changes as voted on in July or recommended by party affairs. We will ask if members wish to discuss the recommendations. But before we begin digging in, we will see if there are any other specific sections that members wish to discuss. Once again, Helen will help us track any sections of the articles that a member has suggested for additional discussion. Once we have a complete list of articles for discussion, we'll begin moving through them one by one. Our intent here is to present the changes we've made for your awareness, bring forth the recommendation for your review, and create space for you to raise any new issues. By limiting our discussion today to our recommendations or new issues, we hope to streamline our drafting conversation and complete the editing process, except for a couple of matters that are deferred until the August meeting, where, once those matters are resolved, the documents can be adopted by the committee and recommended for approval by the full DNC in September. Are there any questions regarding this process? Okay, let's begin. In terms of updates based on our committee's votes in July, Party Affairs has made the following changes. In 1C, Article 1, Section C, Party Affairs replaced all instances of the phrase first determining stage to first determining step. In Article 5, Section C5, we added convention pages to those who have floor access. In Article 6, which states that, quote, the term, quote, presidential candidate, close quote, herein shall mean any person who, as determined by the national chairperson of the Democratic National Committee, has accrued delegates in the nominating process and plans to seek the nomination, close quote, and continues to describe several other measures. We have removed the phrase has accrued delegates in the nominating process and. In Article 7, Section B4, no substitutions will be permitted in the case of standing committee members, except in the case of resignation or death, to replace resignation or death with vacancy. In Article 7H5, we corrected one non-voting member may be appointed by each presidential candidate to serve on the drafting subcommittee to read one non-voting representative may be appointed by each presidential candidate to serve on the drafting subcommittee. And let me see, I don't quite understand what I just read there. Give me
Jim, it's changing member to representative. So replacing the word member with representative.
changing the word member with representative. Yeah, now I get it. It's all melding a little bit, but okay. And finally, in Article 9, Section C4, we replaced the co-chairs shall be divided equally with the co-chairs shall be equally divided as defined in Section 16 of the Charter. In addition to those changes, Party Affairs offered the following recommendations, supported by the co-chairs. I'm going to review them. I'm going to review them before we discuss the individual sections you want to revisit. Please write down any recommendations you'd like us to revisit. And after I finish speaking, I will then ask for your points of discussion. Once we have a list of all the sections we want to discuss again, we'll go through them one by one. Article 9, Section C3A reads, in accordance with the requirements of the 1984 Democratic National Convention resolution, which calls for alternating the convention chair by gender, the permanent chair of the 2024 Democratic National Convention shall be a male. Last meeting, we worked on gender-neutral language for this section that still reflects the intention of the 1984 resolution. We were able to achieve that by changing this section to read as follows. In accordance with the requirements of the 1984 Democratic National Convention resolution, the permanent chair of the 2024 Democratic National Convention shall be of a different gender than the previous chair. If you'd like to discuss any part of this recommendation, please take note now and let us know shortly. Additionally, in Appendix A, the rules of procedure for the Convention Credentials Committee, we have reviewed Rule 13A. Rule 13A says these rules shall be interpreted and applied in the interest of justice and fairness to all parties, speed, and economy. To serve these interests and for good cause, on application or sua sponte, the chairs of the committee shall have the authority to waive any provision of these rules other than Sections 1B and Section 5. Section 5 is with regard to the answer to a credentials challenge. After reviewing this, Council recommends to us that we remove that section reference and expand it to include all of Section 1 in line with our discussion last meeting. So the new rule would then read, these rules shall be interpreted and applied in the interests of justice and fairness to all parties, speed, and economy. To serve these interests and for good cause, on application or sua sponte, the chairs of the committee shall have this authority to waive any provision of these rules other than Section 1. Please use the raise your hand Zoom function to virtually raise your hand if you'd like to discuss any of these recommendations specifically, or if there is a different part of the call you would like to discuss. Veronica, do you see any hands raised?
I am not seeing any. I'm doing a physical hand check. No. Oh, Frank Leon.
Frank?
Yeah, are there any provisions of the call that were we've put aside for discussion in August, or are these the only changes that we're anticipating making? At the last meeting, there was some discussion about bonus delegates. I don't know that we need to revisit that issue, but I don't know if we're planning on doing that later or today, or if we're just happy with the way it is, which is fine.
Veronica or Helen or Rick, are you aware of any that we've put aside for later discussion?
Yes, so we will need to update the dates. And then as Frank alluded to with the bonus delegates, we are working on making sure you all have allocation information on that, but we are working on those numbers.
So we are putting that one aside for August. Anything else? I don't recall anything else. Okay. So anyone else on these issues in the call? Hearing no one on these issues, I would like to return to the topic that Mo raised, and like to hear from members any views that you have with regard to what the direction of the early state discussion. Mo, would you like to lead off?
Sure, thanks. And I appreciate the opportunity to come back to this because I know for at least myself, I am, as we get closer and closer to the vote, would love to hear from everyone else on the committee. I've got a couple of thoughts, and again, appreciate and respect every proposal that was put forward. But I think there are a couple that stand out to me that I'm kind of zeroing in on. Understanding that we are going region by region. I think in at least 3 of the regions, there's a great deal of clarity for me. I think Nevada is a standout applicant in the West. I think New Hampshire is a standout applicant in the East. I think South Carolina is a standout applicant in the South, though I remain very impressed with and intrigued by Georgia. And the Midwest continues to be complicated for me. I think Iowa, Michigan, and Minnesota all put forward very strong bids. For me, I think Michigan and Minnesota are sort of surfacing towards the top, though I tend to lean towards Michigan. The thing that continues to complicate it for me is the question of whether or not they can get the buy-in that they need in order to make the change. And I am very hopeful that one or both of those states can give us the appropriate assurances by the time we ratify a decision in a couple of weeks. So that's the first issue for me, is sort of who represents each of the regions. And that's sort of where I think my head is right now. On the second issue that I've been pondering and reflecting on a little bit about the order, there's sort of 2 issues that come up for me. One, if we go with a bigger state, and I know there's been a number of people on the committee who have raised concerns about going with a bigger state. If we go with like a Michigan, for example, I would hope that because it is larger, that we would consider putting it later in the process. I think by doing so, we can avoid some of the concerns about dwarfing the smaller states that would go before it. But the big question I'm pondering is who would go first. I think both New Hampshire and Nevada have made very, very compelling cases to go first. The least compelling argument that either of them have made is their state laws. I don't think either of those state laws factor into my decision. And as I mentioned last time, I'm hopeful that we get to a point where they no longer factor into anyone's decisions. But I do think they both made very compelling cases. I'm not sure if we were to look at them sequentially, I'm not sure where I fall on that issue, but I remain intrigued by the idea, and I would love to hear people's thoughts on this, of breaking with tradition and putting both on the same day. If not those two, any two, some combination of states. But I specifically think Nevada and New Hampshire going on the same day as the first primary day could be really interesting and could send a very strong message to the country about that we meant what we said in the framework about what we hope this process looks like. And then the third point I will make, and then I will stop, is we've had some conversation about how many states. I lean pretty strongly towards keeping it at 4. As someone who has spent, as many of you, a lot of time working on presidential campaigns, expanding to 5 will complicate things for a lot of candidates in a way that I don't necessarily think is necessary, with one exception. I think it is worth keeping the conversation open depending on which 4 states we lead off with. If neither of the other Midwestern states is able to satisfy all of our concerns, if neither Michigan nor Minnesota is able to convince this committee that they've got the assurances that they need, and we are then going back to the current 4, then I think it is worth expanding to 5. Then I think it is worth exploring adding a 5th state if the first 4 as they stand today remain our first 4, in order for us to better represent and better reflect the criteria we laid out in the framework. So that's sort of how I'm thinking about it heading into August. I remain incredibly impressed with all of them, but those are the ones that really stand out to me. And I think we've got an opportunity by changing to some extent the composition and really rethinking the order and rethinking maybe what that could look like. That we aren't going to be a committee that just stands on tradition, and that we meant what we said in the framework about having an early window that reflects who we are as a party. Thanks.
Thanks, Mo. Are there other comments or questions?
Chair, I see Molly McGarrick has her hand raised, but first Tanya in the chat she asked if Mo could say a bit more about how 5 might complicate matters.
Sure. I'm very sensitive, and I think several members of this committee have brought up a few times in our previous deliberations that you don't want an early process that is overly burdensome, particularly to smaller campaigns, to lesser known candidates who are just trying to get out there and trying to get noticed and trying to make a move. They already have their resources stretched thin. They already have to figure out how to allocate their resources, how to allocate their staff, where to spend dollars. And I think if we have too many states in the early window, it will it just places an additional burden on those campaigns and puts them at a much larger disadvantage against some of the better funded, better known candidates. I don't think it's something we should default to. I think it should be something we only look at if we're not making changes to the composition of the current window.
Any other thoughts or comments on the direction we should be going?
Hi.
Molly.
Chair, we have Molly.
Yes, Molly, sorry.
Thanks. I think I mostly agree with Mo. The part where I'm conflicted is the order. If we look at, and thank you so much for giving us the delegate math. My concern is if Michigan's later, there's an argument to be made that you only need to select, one or at most two of the other three states, and that plus investing in Michigan gives you a pretty significant delegate lead. So I'm just concerned about the spirit of having a window, which is that the candidates compete in every state, and just want to make sure that we're not setting up a process where, again, we incentivize candidates to save time, money, and energy and only go to a certain number of the early states.
Thank you.
I have a question sort of along those lines myself, Mo. Were we to do something as you threw out as a possibility, not as a proposal, New Hampshire and Nevada on the same date, isn't it almost impossible for a small campaign to have a presence in both places, given the distance at that time?
It could be. I don't know, right? I'm not even sure I'm sold 100% on it, but I'm intrigued by it. I mean, campaigns now have to make these strategic decisions. Not every candidate plays equally in every state, even in the current window. Mm-hmm. There are some who, for whatever strategic reason they deem is important to them, will go heavier in one state, will maybe leapfrog a state where they think they might be at a competitive disadvantage and look at the next one. I don't think this necessarily fixes that problem or makes it any worse. The distance is something that I think about. Yeah, I think Nevada and New Hampshire on the same day, the distance could be somewhat problematic. But in the current window, they are that distance still exists. There still is that same distance between New Hampshire and Nevada, and campaigns still have to figure out how to do it by sending a message that we are going to have states like those two on the same day, that we as a party value real diversity, urban, rural, racial, geographic, and campaigns are going to continue to have to make strategic decisions. So I'm not insensitive to the concern, and I think it could be a real one. But I think it's worth exploring. I think it's worth talking out.
Okay, thanks.
Mm-hmm.
Anyone else?
Sure. I saw Donna Brazil's physical hand up. Donna, did you want to speak? Yes, sure. She just confirmed she did have her hand up.
Donna, would you go ahead? Right.
Yeah. Again.
You're on mute, Donna.
Thank you. I want to reiterate what I said earlier about tradition, and that we should not be simply bound by tradition, bound by any other path or any other map or any other dates or any other combination that we've made before. And I say this because the tradition is not always held up well, given the fact that from 1776 to 1920, we struggled to get women the right to vote. And from 1776 to, and I only mentioned 1776 in terms of America's evolution. But we struggled from 1776 to 1965 to make sure that every eligible citizen in this great country of ours would have the right to vote. So tradition often negated the fact that women and minorities, Blacks in particular, who were denied the right to vote, we have not always made good on our promises. I want us to continue to think about how we figure out this story, which is about the future of not just our political party, the oldest political party, but the future of our great country, and what message we're sending to every voter, regardless of their current party affiliation. But I want to speak to that new voter who may not have been, that may be 16 or 17, and may decide that this is the party they want. I want them to see themselves in the future of this party and not see it based on what we've done over and over and over again and time after time, but what we're going to do and say in the future that is about them and their future. So I don't want to, and Mo, I'm glad you put your favorites or your ideas and your suggestions, recommendations. I'm a Southerner. And when I look at this map, which I continue to hold in my hand, I wish there was more than just South Carolina and Georgia, because the majority of Black people live in the South and the majority of Black people vote for this party. And yet when you look at this map, we often forget that. We forget that. We look past the people that have put their investment, their time, their energy, and their concerns in this party. And they want this party to continue to represent them. So I want to continue to look at how we make this relevant to that generation, that voter that we constantly ignore, that it's taken so long for them to get the fruits of their democracy, and only to find out that here, once again, they may not have an opportunity to shine. So I hope we can take a deeper look, a deeper understanding, not just at the dates, 4 or 5. I can argue for 5. I can argue for 4. And I'm not going to age myself. I know I have more presidential campaigns under my belt than a lot of folks, but you can do 4. Absolutely. We proved that in 2008, and we proved it in 12, 16, and 20, but you can also do 5. Yes, we could do 2 on a Saturdays, maybe 2 on a Tuesday, maybe 1 on a Monday. We can come up with the combo platter, but let us make sure when we look at this platter and we look at how we put it together, that we think about those voters that we have overlooked even in the last 4 cycles, that we don't talk to them. We forget them. We don't speak to their values. We've left them behind, the rural parts of this country that often don't even get, spoken to or visited. So I'm still open to a conversation that includes more states, different dates, but more importantly, more states that will give us a better story to tell the American people and a better story to preserve our democracy for the future. So with that, I'll yield back all of the time I've consumed and none of the time that I wish to use on a Friday afternoon. Now that I am free of COVID, I am anxious to drink my wine again. Thank you.
Thank you, Donna. Veronica, I think I see Dennis's hand.
Correct, Dennis, and then Chair Lewis.
I'd like to amen everything Donna just said and say, you can get all those things in Texas, but I understand our size. I will say this, Mo, just thinking about putting 2 states on the same day, if it's New Hampshire and Nevada, I worry about the signal that sends to the Hispanic voters of Nevada, especially given, at least in Texas, the movement of some Hispanic voters away from our party. I don't want to send that kind of message. But there's also Pacific Islanders and Native Americans that are there in Nevada that might feel slighted by sharing a date with New Hampshire. So I just want to put that on the table. I have been one that has thought about putting 2 states on one day. I just worry about what kind of signal it sends to some of those who we're trying to invite into this party, as Donna says.
So I think you're right. One reason we're not jumping to do this all at once is so that we think of unintended consequences.
Mm-hmm.
Yvette.
Thank you, Mr. Chairman. I'm going to just sort of amplify a little bit of what Donna just said, because I totally agree 100%. Last summer, I think it was, I read the book Caste by Isabel Wilkerson. If you haven't had a chance to read it, you really owe it to yourself to read it.
I have, and it is fascinating, yes.
It really is. And there's a whole section in there where they talk about the Republican Party and how the Republican Party takes care of their dominant caste, but the Democrats don't. And our dominant caste is the African-American vote. It is the vote of people of color. And how the Republicans will bend over backwards to make sure that part of their party is heard, that part of their party is taken care of. Democrats don't, but they expect that part of their party to show up time and time and time again. And as Donna was talking, I could not help but reflect on reading that section in the book and having this aha moment and saying, that is absolutely correct. It's just show up, vote, we'll get to you when we get to you. If that happens to be, y'all wait your turn until we get to South Carolina, then that's what it's always been. And I just think that we really need to think differently. We need to think more strategically. And I have standing. I can say this because this is what we're doing in Maryland, right? We did it. We are doing it in Maryland. We are saying to people in Maryland, you matter. We recognize the importance of you to our party. And we are going to elect people that look like our party, the most diverse state on the East Coast. So, Donna, I second that emotion. I just had to sort of amen corner that, because it is true. And time after time after time again, the African-American voters are told to wait. And in this Democratic Party, we should not be told to wait.
Thank you very much.
Chair, yes, we have Carol Fowler, then Donna Brazil, and Lee Saunders.
So I'm going to alter that just a little bit. I'm going to go to Carol, then Lee, since he has not spoken, and then back to Donna.
Thank you. I actually had taken my hand down, but I will go ahead and ask my question or put forward my thought, which is we haven't talked much about the fact that some of our states have laws that say they have to go first. If we put two on the same day, how does that affect their laws? We just have not talked much about this. And as somebody said at our last meeting, if we pay too much attention, which we always have, to the states with laws that say they have to go first, next time there'll be 8 or 10 states that have laws that it doesn't take much to get a law like that passed in the state legislature. And I don't say that we should ignore those laws, but I do think we are going to, at some point, as we set this schedule, have to discuss the effect that those state laws will have on what we do.
Mm-hmm.
Okay. Lee Saunders.
First, let me apologize for not being at the previous meetings where the plans were being reviewed. We had some very important business within my union as far as the convention. But I do want to go back to what we talked about at our very first meeting and the importance of having diversity, of recognizing those that have stood with the party. And I've got to agree with what Yvette and with what Donna said. It is time, if we're going to make a move and make change and do what's right, then I believe that we've got to move a state up where there is active participation by specifically the African American community. It's time. It's time. And I get it with what Mo was saying, but I would urge us to think a little bit more about the order and about having a state that is more diverse leading the way. Or I don't know if it's a good idea to have one or two in the beginning, but we've got to grapple with this problem, and we've talked about it before. And I don't think we can run away from it and say, well, we discussed it, but it's not time. It is time. So, I mean, I think that we've got to look at the states, and I think it's in the South, whether it's South Carolina or Georgia, where the backbone, in many cases, of the Democratic Party, who have played by the rules every single day, should be rewarded as far as moving them up and having them in an important position as far as the start of the process. So.
Mm-hmm. Thank you, Lee. Were there any more questions in the Harper or comments?
I guess we do not have any right at the moment. I think that between now and our August 5 meeting, we will be talking with each other offline. We'll be hearing from I think, other states by certainly, and we encourage them to send in additional data to Veronica and the party affairs staff to share with all of us. We don't really encourage them to be calling each member of the committee individually. Not that there's any way we can really stop that. For example, New Hampshire sent in some additional data today, and as we prepare our summary sheet, we will make sure that everyone's aware of those things.
And Jim, I just want to, if I might, I just want to add too that, first of all, as just a political practitioner without being a co-chair, I think the vigor in which this committee is approaching this has been especially helpful for me, and I know for Jim. And then with us doubling back, talking to the states, I don't think there's any easy challenge here, but I am reminded of something that Leah said in one of our meetings, and that's how we look at the words diversity and what it means in the context of this party. When I listen to Donna talk about young people, when I listen to others talk about Hispanics, Blacks, all of that stuff has to be taken into context as we look at this new invigorated party. And so, while it feels challenging on the one hand, to me, I'm really hopeful that we'll land in the right place, just listening to the committee members. So I thank you for all of the comments that you're making, because they all add up in the end.
I totally associate myself with those comments, and not being aware of anything else, I'm going to turn it back to you, Mignon, for our wrap up here.
I love it when Jim turns it back to me, because we just wrapped up. So members, we have come to the end of our agenda for today's RBC meeting. So before we go, are there any more comments or questions?
I am not seeing any hands, Chair.
Well, seeing no further questions, I do want to thank each of you. And I'd also like to thank the past staff and the entire DNC, the AV teams, the technicians, our interpreter, and our court reporter for making today's meeting happen. We have completed our business today without objection. We stand adjourned.
Thank you, everybody.
Thank you.